without wasting time, since we are running late, we will be moving on to the next technical session. And for that, I will hand over to my fellow colleague, Roderick Mario.
Okay.
Roderick Mario, can you hear me? Mario, can you hear me? I suppose there is some technical glitch there. So I would be taking over this session.
So, William, so I would like to call on record.
Mario, we cannot hear you.
त्याच्यावर काय नाही यायचं, त्याच्यावर लिंक नाही आहे, याच्यावर लिंक आली, लिंक इकडे मेल करायची, आमचे रेकॉर्ड
Sir Ravindra, I would welcome you on behalf of the team, which is Sir Ravindra. Dr. Ravindra Chingle is the advocate on record to the patent officer. So we welcome you on board to chair the session.
Hi, is it audible?
Yes, sir, you are audible, sir.
So thank you so much. So if all participants are there, then we can start the session.
And sir, we apologize for the technical glitches that occurred.
So I think there are.
I would request. Yes, sir. There are four participants, sir, in this session.
Yes, I have got the information about the session. So 4 participants, and they are speaking on law.
Yes, sir.
Law and related issues. So if all the participants are there, then we can start the session.
Yes, sir.
Yes, sir. We can start off with the session.
So who will start the session, or what is the order, or the order has been written in the...
Sir, Dr. Sushma Sharma, Assistant Professor, Sikkim Government Law College, will be starting off by presenting her paper. The title of the paper is Women and Their Safety in Modern India, Concerns and Challenges. Over to you, sir and ma'am.
Yes, you can start. Introduce yourself and
Okay.
Start. It will be better because this is a relevant
Yes,
topic
sir. Yes, sir.
of women and society. So considering the ongoing development, we are very eager to know
Yes, sir.
how you have evolved and developed your conceptual thoughts. So over to you.
Good afternoon, everyone. And with due permission from the chairperson, sir, I would like to proceed with the. I would like to present my paper. I would like to take permission to share my screen. I'll just try to share my screen.
Yes, ma'am, you can share your screen.
Yes, I'm doing it. Is it visible?
Yes, ma'am, your screen is visible.
Okay, thank you. So the topic for my presentation is Women and Their Safety in Modern India, Concern and Challenges. Women is a symbol of love, purity, knowledge, sacrifice, and women are integral part of the society, and thus the progress in any society largely depends on the advancement of the position of women in the society. In Indian context, there has been changes in the position of women in the society. Women of modern India has achieved a lot compared to the women in ancient and medieval period. Today, we can see women in every field and they are excelling themselves to a new horizon. However, are women safe in the society? Why there is increasing concern for safety of women in modern India, especially during COVID-19 pandemic? Modern women are coming out and they are facing the world with dignity and freedom. They enjoy autonomy in economic and political sphere, contrasting to the past where they were treated as subordinate to men. There has been changes in the social structure of the society and women have been enjoying their rights and freedom. But in spite of all this, there is a harsh reality that women are subjected to discrimination, harassment, and violence just because they are women. The increasing number of violence against women, especially during COVID-19 pandemic, clearly shows that women are not safe in the society. At one hand, women are given opportunity to go to school, work outside, to choose partners, and to choose even motherhood. But on the other hand, women are subjected to sexual abuse, molestation, sexual harassment every minute. Ever since the horrific gang rape of Nirbhaya in Delhi in December 2012, a huge question of utmost importance is raised: how far women is safe in the society? In fact, Nirbhaya is not the only case. There was rape and murder of women before Nirbhaya also, and even after Nirbhaya. Women are prone to crime against them just because they are women. Crime against women have recorded as 83% increase from 2007 to 2016. However, the conviction rate is as low as 18.9% in 2016, as per National Crime Bureau record. However, if we see the latest National Crime Record Bureau, which has released on 29 September 2020, an average of 87 rape cases were registered daily in India in 2019. Cases registered under crime against women rose by 7% relative to 2018. And the population level survey also reported that only 3% cases of violence against women has been reported in India. Some of the instances, like in Kerala, one of the member of the state's women commission got a call from Chennai pleading for help by a man who said that her sister, along with her daughter, resident of Udupi district, are hiding in the forest as her sister's husband has ejected both of them out of the house. The man said that there are wild animals in the jungle. The case was investigated and the husband was taken into custody. In Malda, West Bengal, a 26-year-old woman who has been married for past 5 years was allegedly strangled by her husband. In another incident, a man killed his wife after she protested against his alleged extramarital affair. Now, these are the few instances I am referring. There are many such incidents which are reported, and perhaps unreported cases must be more than the reported one. So the National Commission for Women claimed that there has been rise of 94% complaint cases, including that of domestic violence, after the outbreak of pandemic followed by lockdown. Between 23 March 2020 to 16 April 2020, 587 complaints have been received, a significant surge from 396 complaints received previous 25 days. So this includes the complaint received through WhatsApp and other modes of communication. There are agencies which reported that there has been increase in domestic violence cases both in urban area and rural area during lockdown. This figure represents that women are being abused in public and private sphere. They are not even safe at home, and unfortunately, it is just not women but girl child also. there has been increase in the number of child abuse in India during 2020 to 2021. This manifests that women are already facing structural gender-based violence and now more prone to this violence during lockdown period and making them more disempowered. If we see law relating to women, there are various laws existed in India for the protection of women. Article 14 of the Constitution of India guarantees equality, and Article 15 ensures positive affirmation in favor of women and children. Article 21 provides right to live with human dignity. Crimes against women has been broadly classified into two categories: crimes under Indian Penal Code and crimes under special provisions. So, Immoral Trafficking Prevention Act 1956 to prevent trafficking of women, Protection of Children from Sexual Offences Act 2012 to protect girl child from any kinds of sexual abuse. So these are the laws. There are many laws for the protection of women, but still women are facing challenges in terms of safety. The voices have been raised by various sectors, articulating demand for safety by women's group, academicians, students, media, and political parties. The significant part is that this lockdown has further increased and aggravated the crime against women. Home, which is assumed to be the safest place for everyone, seems to be not safe for many women. In India, patriarchy, clubbed with gender insensitive policies, is shrinking the women's autonomy and have reduced women to second-class citizens. In the case of All India Council for Human Rights, Liberties and Social Justice versus Union of India, the Honorable Delhi High Court directed the government to deliberate on measures to ensure effective implementation of Protection of Women Against Domestic Violence Act 2005 in the wake of increasing in the number of cases. On 5th April 2020, the United Nations Secretary General called for to end all kinds of violence so that they can concentrate on the pandemic. Violence against women and girls is increasing globally as the COVID-19 pandemic combines with economic and social stresses and measures to restrict contact and movement. Crowded homes, substance abuse, limited access to services, and reduced peer support are even exacerbating these conditions. Before pandemic, it was estimated that 1 in 3 women will experience violence during their lifetime. However, many of these women are now trapped in their homes with their abusers. So in order to, there are various initiatives that has been taken, like we can see that the government has taken various initiatives: Beti Bachao, Beti Padhao Yojana, Samriddhi Yojana, National Policy for the Empowerment of Women 2001, and many more. Even NGOs are there which came out for the protection of women. Even after all this, we cannot deny that safety of women is still not there. Various reasons are responsible for this, and various measures must be taken in order to ensure safety of women. It is necessary that there must be national response plans to prioritize support for women, with measures including integrating prevention efforts and service to respond to violence against women, designating domestic violence shelter as essential service and increasing resources to them, designating safe spaces for women where they can report abuse without alerting perpetrators, example in grocery stores or pharmacies, mobile service to women in need of help, awareness campaign at community level involving more men in the task, and also to raise girl and boy child in a gender-free society. Women must be taught self-defense techniques and there must be equal share of the property. These are some of the measures which we can adopt in order to ensure safety of women. And however, safety is not issue just in India. In other parts of the countries also, there are issues relating to safety. In Canada, the government's COVID-19 response package includes pound 50 million to support for women facing sexual and other forms of gender-based violence. In Australia, pound 150 million of the national response was earmarked for family violence response. However, there is no such national response to violence against women in India, especially during lockdown. There is need to evolve guidelines and framework to provide immediate and long-term relief to women, immediate support to be rendered to calls received through helplines and through other means. Coordination should be made between the CAW cells, the district control rooms, and help desks. Women, police, and counselors may be sent to visit the callers to help them. There must be inspection of the areas where there is more number of crimes, and action must be taken against the perpetrators on suspicion only as a preventive measure. So, at last, I would like to conclude that safety of women should be given priority at the national level to ensure that every woman is safe at public and private sphere. Government should acknowledge that there is issue of safety in India for women, and gender-based violence is the reality of social fabric in India. Therefore, reframing government policies and coordinating support system at community level would be helpful for victim women. So, if safety is ensured in the society, then the dream of gender equality in India may be realized. So, at the end, I would like to end my presentation with the quote: "Peace and prosperity lies in the society where women is happy and honored." Thank you.
Thank you, Sushma ji. So, Dr. Sushma Sharma has enlightened us with different aspects of women and their safety in modern India. What I propose that we should first go through, or we should allow first all the presenter to present their topics, and then we'll come back for the question and answer session. So,
Yes.
I'll request the organizer, Krushanu. So, please call the next presenter.
Yes, sir. For the next up, we have a joint paper presentation by Dr. Tanjakup Tombing, Assistant Professor of Law, NLU Assam, and Ms. Benchilo Odio, PhD Research Scholar, NLU Assam. The title of their paper is Status of Naga Customary Institutions of Administration and Justice System, a Critical Legal Analysis.
Hello, sir. Sir, I'm audible?
Yes, you are audible and visible also.
Okay.
So, first introduce yourself and then start the presentation.
Okay,
You and
sure.
also your co-author.
Yes, sir. Good afternoon, everyone. My name is Benchulo Odio. I am a research scholar at National Law University and Judicial Academy, Assam. Today, Professor Dombin and I will be presenting the paper on the topic status of Naga customary institutions of administration of justice system and critical legal analysis. So first of all, since we will not be using PowerPoint, I would like to give you the segment of the research. So first, after the introduction, we will be dealing with the administration of justice in the pristine Naga society. Then we will also be dealing with the impact of British administration on Naga customary laws and institutions, and the impact of Christian missionaries and political awakening in Nagaland. And then we will also be dealing with the post-independent and Naga insurgency and the Constitution of India and Naga administration of justice system. And then comes conclusion and suggestions. So now let me proceed with the introduction. Nagas have been fighting for self-determination for a very long time. And the reason why they are fighting for self-determination is because they have this unique and peculiar history and culture. In 2015, government of India and Naga insurgent group signed a treaty which is known as Naga Peace Accord. And in this treaty, the leader of the NSCN demanded for separate flag and separate constitution, but this demand is yet to be fulfilled. There are different tribes in Nagaland, and these tribes have their own uncodified customary laws. And these uncodified customary laws are protected by the Constitution of India under Article 371A. Now talking about the administration of justice system in the pristine Naga society, Nagas have an informal justice system under customary laws, and the delivery of justice is performed by chief village and chief village and village council by way of summary trial in all cases. But during the British rule, even though the Britishers did not interfere in the administration of justice in local affairs, the Britishers established formal laws and formal institutions in this region with the help of the Christian missionaries by introducing Christianity in the region. So now they have both formal and informal justice system. And with the emergence of Christianity in this region, education was also introduced among the Nagas, and the Nagas were educated through Christian gospels and preaching, and this actually helped them to realize their ethnicity and unification of the Naga tribes. And as a result, after the First World War, Naga political parties like Naga Club and Naga political conventions were formed in order to fight for their recognition. And also, one of the impacts of the Christianity in this region is that traditional institutions like Morong, which was used to enhance the traditional practices and customs, started to deteriorate, and these institutions were replaced by the modern institutions. So now talking about the administration by the British in this region, Naga Hills was fragmented by the British rulers into 3 zones. That is administered zone, then politically controlled zone, and beyond political control zone. Initially, this region, the Naga Hills, was administered directly by the Lieutenant Governor of the Bengal. But after, with the passing of the Assam Scheduled District Act in 1874, Governor of Assam was entrusted with the power of administration of this region, and the Governor of Assam administered this area with the help of the Deputy Commissioner in district level, and with the help of the Kaumburas and Dopashis in village level. So in village level, Kaumburas and Dopashis were appointed by the government as an agent, and their power, the power was strengthened by the rule for the administration of justice and police in the Naga district, in the Naga Hill District Act 1937. So with this, I would like to conclude my presentation and yield the remaining time to Professor Tombin. So, sir, over to you.
Am I audible?
Yes, sir, you are.
Okay, so I'll take it from here. Now, this paper is a work in progress, and it take forward the other issues which will be coming and which have to be properly addressed once the peace accord, and then the concerns, and then the conditions which the government of India has, and with the state of Nagaland, and also the NSCN, and also the civil society. Now, the legal theory that is being, and legal presumption that has been made in this paper is that somehow, even if there is this aspect of administration and then political control, and then also of the other aspects of political control with regard to excluded and partially excluded areas, and that philosophy getting expressed in the Government of India Act and also in the Constitution of India. The idea is that the Naga customary institutions, which was a robust one and which was self-sufficient in the context that it was able to manage and administer justice among different tribes of different scattered tribes, or maybe different subsect of Naga tribes, whether it was in the area bordering pure Nagaland state or in the contiguous Naga inhabited areas, which may be not just limited to the Naga territory, Nagaland state territory, but to other states like Manipur, where a major chunk of Naga people also live. But then, and then the idea was that in that administration of justice, there was this part of the criminal administration of justice and then the civil administration of justice. But then that bifurcation is not found in its pristine inception, right? And then the idea was that whatever the Tar Council or maybe the inter-village dispute settlement mechanism which were there, whereby there's a certain kind of a hierarchy, it has now been intervened by the British colonists, and then that idea of them bringing these aspects of formal legal system, and then also in that larger context of the District Act 1874, then also the Assam Frontiers Tract concerns, and also in the context of the Bengal Eastern Frontier Regulation Act, and also the aspect of the Assam Police Officer Regulation 1883 with regard to state-specific and region-specific, all those which have been enacted for time to time. Now, the legal analysis in that context is that somewhere that sovereign institutions which were there in pristine Nagaland state or maybe pristine Naga communities, their glory and then their sovereign nature of them, whereby they can deal with any form of offense, which may be from petty crimes to even matters of murder, now has been stripped and then replaced with being subordinated to the executive magistrate or the district commissioners as per the orders of the governor and relevant orders of the rules and regulations that have been passed from time to time. Now, once that intervention has happened, the idea is that that glory and then that authority it used to have now been replaced as merely a political and administrative exigencies, whereby the aid of the DC or maybe the Gaumburas or the Basis are being brought in. So what happens to that institution? Now, in fact, that the political awareness among the Nagas have already started in the early 20th century, and then that has to do with the British education maybe, and then also the missionaries' education. And another important factor in that context was in the First World War, there were around 2,000 Nagas were taken to France to fight the First World War, and there the people who have gone have a certain kind of an exposure to what was what we now call our European philosophy or Western philosophy. And when they came back, there was certain kind of a political awareness, and that led to the creation of the Naga Club. And this wing became very important in their assertion for self-determination. So, and that has been going on, in fact. And then in the referendum, majority of the Naga community did not ever want to be under the Union of India. So that part is the insurgency part. And then because of all those concerns, even when the sixth schedule aspect was brought under Article 244, the primary plan was to bring the Naga inhabited areas under this administration. However, since it was rejected, then the Nagaland state came about. Now, it is very important for a law student and then for researcher to look into this aspects of Article 371. Article 371 is a special provision with regard to the state of Nagaland, whereby it says, notwithstanding anything in the constitution, no act of parliament in respect of religious or social practices of Nagas, Naga customary law and procedure, administration of civil and criminal justice involving decision according to Naga customary law, ownership and transfer of land and its resources are applied to the state of Nagaland unless the legislative assembly of Nagaland by resolution so decides. So this is a constitutional scheme whereby the idea of constitution within constitution, that provision has been born. If I borrow from Justice Siddhartullah, that observation that he has made. Now the idea is, when you say that a Naga person shall not be governed by any centrally enacted law of the Union of India, and then that has its implication in the administration of civil and criminal justice and involving decisions according to Naga customary laws. What would that mean? Now, the sovereignty and then the glory of the Naga customary institution has already been intervened, and that organic growth has somehow been stalled, right? And then under the constitutional scheme of things, there is an idea of its being symbolically revived, but with a very strong mandate also. But then where does the system stand? Where does the criminal justice system stand? So it is very pertinent that in the course of a protracted insurgency movement, there is supposed to be a possibility, and in fact there has been cases that violation of human rights would have happened, maybe by state actors or maybe by non-state actors also. So thereby there is a requirement to also analyze how this human rights aspect should be discussed from that context of the immunity which is there under the Armed Forces Special Power Act Section 6, and also in the larger universal context of rights of women and children, because in an insurgency or in armed insurgency, the human rights are never suspended, even in an armed conflict. And even if there is no mechanism whereby a certain voice can, the voice of a vulnerable section section of the society cannot be raised, then does it come to an amiable solution, and would it lead to a fair settlement of whatever the protracted insurgency would be? So here, the paper, in the paper, it was found required that how do we bring in or interject that idea of administration of justice, and that justice is not merely of the Naga communities, but also of the communities and then the people who have been affected by the protracted insurgency movement, and not just of the protracted insurgency movement, but the idea is when the terms and conditions of the governments and then the deal that is going on between the insurgent groups and then the government of India, though it has run into a stalemate because of the demand for separate flag and separate constitution. But if it comes into fruition, how would certain issues be settled? And there would come the next phase of governance, and that governance will form, in that major chunk of the governance will be an idea and aspects of administration of justice. So when in that administration of justice, how would that idea of rule of law be read? So can that idea of rule of law and then administration of justice and then a procedure established by law, can it be as per the past customary laws and institutions, which have not grown, which have not organically grown? It has been stalled, but because of certain rules and regulations, it has been now symbolically retained, and then the features of what it was has now been replaced by certain special provisions. So in the light of all this situation, facts and circumstances, it is very important. How do we deal with the concern of child soldiers? How do we deal with atrocities being committed to women during the course of all those insurgency movements, and also later on other social problems that are already there and which also will come about? So the paper, keeping in mind that peculiar jurisprudence, as is stated and as it is formulated, that there's a peculiarity history part of it. Can there be an idea which is more progressive and which will also take care of the concern of administration of justice, which will be based on equity, justice, and fairness? And the paper studies in that context relevant conventions, international conventions and treaties, and also certain judicial opinions with regard to concern of victim rehabilitation and reintegrations also. This shall be it for today's presentation. If any query are there, we are open for queries. Thank you.
Thank you, Dr. Tomlin.
Thank you.
So it's nice to meet you again on this virtual platform after a long time of 8 to 9 years, almost. When we have introduced each other at National Law University, Delhi.
Okay.
In 2012-13.
Okay, sir. Okay.
If you remember.
I recall for a program on administration of justice, I think. Yes.
Yes. So it is very nice to meet you. So we'll just go for the next presenter, and then the timing is, I want to just inform the next presenter that timing is just 10 minutes for the presentation. So please try to conclude within 10 to 12 minutes. So Krishanu, so can you just introduce to the next presenter?
Yes, sir. The next presenter will be Dr. Asma Rahman Punjabi, Assistant Professor, School of Law, University of Kashmir. The title of her paper is COVID-19 Measures and Medical Professionalism in Recent Times, Necessary Protection or License to Kill. Over to you, ma'am. Ma'am, could you please unmute yourself?
Good afternoon. Thank you, sir. This is Asma Rahman Punjabi, Assistant Professor, Contractual, School of Law, University of Kashmir. And so far as the title of my paper is, it's COVID-19 Measures and Medical Professionalism, Necessary Protection or License to Kill. As we all know that we are in a COVID-19 pandemic, and so far as this pandemic is concerned, it's just akin to a battlefield. Although there may not be any active use of traditional weapons, artillery and battle tanks, still people are dying because of the minuscule particles that are not even visible to the naked eyes that occupy human body and leave its organs, or we can say the vitals, dysfunctional in a jiffy. Like we have soldiers on the battlefield, medical professionals form an essential part of an effective response to the pandemic. A medical professional, by virtue of the powers vested to him because of his skills, knowledge, and training, he is obliged to follow an ethical code of conduct. To make medical professionals more responsible, accountable, and quick-witted in the pandemic for the noble cause of humanity is possible only when they are subject to a strict legal control. So far as I am concerned, I am of the view that medical professionals during the pandemic should not be allowed to visit their homes till the pandemic ends, because it creates chaos and confusion in their localities, including their families, because they are more vulnerable to the infections. So in order to facilitate this provision, government should provide them immediate accommodation in the hospital premises so that they would be available round the clock, like soldiers can't abandon battlefield till the battle ends. In addition to this, there should be continuous training sessions for medical professionals which train them how to confront and combat pandemic. During pandemic, as we all know, that medical professionals, they are the superheroes and ultimate hope to the whole humanity. So far as their profession is concerned, this is a very noble profession, as itself symbolizes their significance, like soldiers prefer sacrifice, not defeat. So far as this dichotomy between the soldier and medical professional, it's same, because both are working for the safeguard of their people. However, unfortunately, medical professionals forgot that they are superheroes, or we can say the super soldiers. That is why laws related to medical professionals, or so far as the pandemic is concerned, they are of utmost need, and these laws are to be enforced and implemented on the ground that no one should escape with sheer excuses. So far as the people are concerned, people are alleging nowadays grave negligence and mismanagement on the part of the medical professionals, which result in an abrupt death rate. As we all are aware that when the second COVID wave hits the India during the second week of the March, people were dying like anything. Whether it was scarcity of the oxygen in the hospitals, it was because of the lack of supply of life-saving drugs, or it was because of the non-availability of the beds, non-availability of the medical professionals. The death rate, it was an alarming. So who was responsible for all this? Why people in the hierarchy or people at the administration, why they are not taking this thing into consideration and do something so that we may not be faced with this scenario just after this pandemic, because this sort of pandemic, it may hit anywhere and anytime. We should learn a lesson from this, like from this example, that we have to equip ourselves with the best possible with best possible equipments, professionals, and the other things. So far as the laws concerned medical professionals are concerned, we have a lot of laws. There are statutes which regulate the conduct and practice of medical professionals, which safeguard and the rights of the patients. But the need of the hour is that these laws should be implemented, and we should have the new laws, or we can say the new laws should be introduced. Like we have the Epidemic Disease Act of 1987. So far as the Section 4 of the Act is concerned, it's solely applicable to medical professionals and provides legal protection to every person who does any action in good faith. This section basically provides immunity from legal action for any medical profession acting under the provisions of this act. But somehow this good faith has a negative impact when it comes to justification. So the need of the hour is that the strict amendment is mandatory, so that we may be in a position to bring a fear in the minds of the professional that if they fall below the standards, or if they are short of their skills, they may be made accountable for the same. That is why like we should have the new laws, or with whatever laws we have at our hands, they should be implemented in the letter and separate. We all are aware of this pandemic. Nowadays, we have one more term, that is meddling. This is another unfortunate business. We all know that the mere final year MBBS students, they were asked to work under the guidance of consultants. The issue can arise when a task that is typically and appropriately completed by the lesser skilled, it may sometimes prove to be fatal. Not only fatal, it may prove disastrous. A junior doctor with limited or no experience of the procedure to be undertaken, he may lack adequate understanding of the nature of the operation, including the possible risks and complications, to explain the procedure in appropriate detail to the patient. So far as the delegating doctor is concerned, he must be satisfied that the person to whom the task is delegated must not only have the necessary knowledge and experience, but he should also have the qualifications and skills to provide the care or treatment. Otherwise, the delegating doctor also has a duty to ensure that the patient has given their consent before the investigation or treatment begins. Now, the question is whether the consultants adopted the same. If not, why not? If they have not adopted this procedure, why they have not adopted this? Who would be made accountable? We have the laws on this point also. That is, we have Section 7 of Indian Medical Council Regulations of 2002. It talks about that physicians shall not claim to be a specialist unless he is a special qualification in that branch. The duty of a physician can't overstep his sphere of training and expertise, and to limit their practice within the ambit of these qualifications. We have one more provision, that is Section 4 of the same regulation of 2002. It says that whenever an epidemic occurs, a physician should not abandon his duty for the fear of contracting a disease. Physicians need to perform their duty in their core competence. And so far as the Section 8 of these IMC regulations of 2002 are concerned, it talks about the punishment and the disciplinary action. I may not talk about the rest of the Indian states, but I may talk about my own state, that is the state of J&K. We have this province, that is the Srinagar city. We have here the main government run hospitals. During the last episode of the COVID-19 wave, the COVID positive patients or the patients suffering from the other diseases, they were left on the hospital beds at the mercy of the juniors. Not even the senior residents, they were the junior residents and the mere PG students. So where is the administration? If we have the laws, we have the procedure, then where are the laws? Who are going to implement these laws? My question is open to all of you. If we have the Medical Council Act, if we have the Code of Medical Ethics, then why all this is happening in our nation? So my point here is that it is of utmost pertinence to stay side by side with the latest government guidelines and regional policies and follow them prudently. The medical practitioner and the administration, they are duty bound to be prepared to deal with all eventualities arising for admitting or treating a COVID suspect or a positive patient. The admission or treatment should only be performed if the hospital is authorized to treat COVID positive patient. And if anybody fails to adhere to the guidelines, he would surely invite the wrath of government bodies and adverse legal consequences. Because of the shortage of time, as I have been given only 10 minutes, let me conclude my presentation. And at the end, I would like to say that this coronavirus pandemic, it has happened once in a century. And so far as this pandemic is concerned, it has impacted every single human living being at this moment. Leaving aside the living beings, not even the dead were spared of its threat with respect, proper burials, and cremations. Amid these grotesque times, it's true that medical fraternity has to be at the forefront of this fight. It must also be ensured that their human needs are adequately addressed by the authorities, including welfare of their families. Also, it is imperative upon government to first ensure nobody dies because of any medical negligence. And secondly, if it happens anywhere, we must ensure that erring medicos are identified and punished exemplary for their derelictions. But alas, I have not seen this thing happening in our nation, particularly in my state. So far as the medical professionals are concerned, they have the moral duty to think beyond the monetary benefits because of their nobility of the profession and put themselves wholeheartedly in saving human lives in times where death is looming large. History will ensure that your service will be remembered for many centuries to come, and God forbid, if you fail to deliver, you will be cursed for hundreds of years to come. It's you who has to decide whether you want to be remembered for being on the right or wrong side of the history. Choice is yours to make. Thank you all. Thank you for patient hearing.
Thank you, Dr. Asta. It is really very enlightening to hear the different aspects of effect of post-COVID, or you can call it as a COVID-19 on the medical profession, or in a way that the impact of medical profession on the life or lives of people. So you have tried to cover the exact problem which has been faced by the people in this COVID-19 pandemic. So thank you, Dr. Asta. So I think we'll move for the next presentation. So
Yes, sir.
Kushanu, you can just introduce the next presenter, please.
Yes, sir. For the last presenter of this session, we have Pulak Simon, National Law School of India, University, Bangalore. The title of the paper is Critically Understanding POSCO Act, Incorporating Skin-to-Skin Judgment to Expanding the Scope of POSCO.
Good evening. I'll just share my slide.
Sure, sir.
Please be ensure that you have 10 minutes for presentation.
Okay. Um, Sorry, I couldn't share my slide. I'll just directly talk about my research paper. My
You can try again to share your slides because it will be easier for the other viewers also.
yes, I'll try it again. It's not working.
Okay, no problem. You can continue.
Yeah. My research paper is on critically understanding POXO Act, incorporating skin-to-skin judgment to expanding the scope of POXO. The introduction is as follows. The road to recognition of a comprehensive development of human rights demands...
Please introduce yourself also.
Oh, yes. I'm Pulak Simon. Actually, I did my master's from National Law School, Bangalore. Now, presently, I'm a research scholar in NLU, Guwahati. And you know the title of my research paper, so I'll just move forward with the introduction. So the road to recognition of comprehensive development of human rights demands protection of child rights law. The Constitution of India embodies child laws, but its effectiveness will be of some dejection. Children are tender and immature, considering their age, marking them vulnerable. So it is of point essence that special laws are enforced to safeguard their rights. The birth of POXO Act 2012 eventually was a major leap from anarchy against child laws. It was embraced by the citizens but has been criticized as it burgeoned. Regular judicial interventions are necessary to plug the lacunae, but how effective are the judges to handle the POXO cases are a matter of concern. The recent commotion relating to the skin-to-skin judgment delivered by the Nagpur bench of the Bombay High Court questions the incompetence of the judges. The issue waves a red flag on the judiciary as it attributed to the epitome of justice. The delivery of the judgment juggles the issue of groping a minor over her garments without skin-to-skin touch, as it will not tantamount to sexual assault under the POXO Act. The alarming state reflects that the law or the judges are at loggerheads with the present state of laws. This research paper will plunge to frame lucidly as to how the cohesion between the international laws and the national laws run to dispense the special laws to protect and uplift a sexually abused child. Laws are just one side of the coin, the other is the mechanisms initiated to protect them. Understanding the infrastructure and the delivery of judgments will aid to critically analyze why are the rates of child sexual abuses still rocketing. To make it more comprehensive, study will be done considering the data of various states. So lastly, broadening the scope of POXO will also be analyzed. So starting with my first chapter, it is on the legalities of the POXO Act, revisiting the international and the national laws. So tracing the roots of the POXO will lead us to understand the four broad pillars of the United Nations Convention, the UNCRC, and the framework summarizes the civil, political, social, economic, and cultural rights of every child. They are identified as right to development, right to participation, right to protection, and right to survival. So these pointers are also mirrored in the Constitution of India, 1950, and also especially in the fundamental rights of the Constitution. The rights also further trickle down to be observed in Juvenile Justice Act 2005 and POXO Act 2012 altogether. Then channeling the way through the international framework needs a glimpse through the international instrument on child protection as to how did the incorporation of child protection come to existence. So firstly, the UDHR acts as a cornerstone to spring through the declaration the concept of vulnerable group which comprise children in it. And also, the understanding is that the child has to be granted all rights of special care, special protection, and deserve basic standards of living. Secondly, the ICCPR was crafted to be a legally binding treaty, unlike the previous declaration. ICCPR stressed on a new aspect, that is identity of a child. It is emphasized on the state parties and the active role that they should play on documenting when a child is born and their identity reflects oneself in the society. And thirdly, the ICSCR, it focuses on children working in hazardous areas, and also includes the idea of right to education, where the idea for free primary education for all was also pressed in it. Then going briefly through the special instruments of the child protection, that is the Declaration of the Rights of the Child 1924, it also focuses on the proper shelter, care, and protection. And secondly, the Declaration of the Rights of the Child 1959 focuses on the best interests of the child. And then thirdly, the United Nations Convention on the Right of the Child 1989 focuses on the non-discrimination, best interests of the child, survival and development, participation or inclusion. And fourthly, the optional protocol to the Convention on the Rights of the Child on the sale of children, prostitution, and pornography combats the worst forms of human rights violation against children, and to more efficiently and effectively deal with child victimization, sex trafficking, child pornography, and child prostitution. Now, narrowing it down, dealing with the Indian laws and the POCSO. The international framework of laws has been accepted and respected in the Indian legal framework through the Indian Constitution 1950. Article 51 Clause C, it states to respect the international laws to every possible extent. Under the constitutional perspective of child protection laws, it includes the CRC, the optional protocols of CRC, UDHR, ICCPR, etc. The Constitution of India basically also includes the assimilation of all international child protections in Part 3 and Part 4 of it. Also, the IPC deals in various sections with issues of child protection. The laws of child rights has been incorporated, but to reflect the child sexual abuse was still absent. It is only recently that child sexual abuse is acknowledged in India. Before 2012, the offenses which concerned with child sexual abuses were shielded with just 3 sections of IPC. That is 376 of IPC, 354 of IPC, and 377 of IPC. And as we know, in December 16, 2012, the Nirbhaya rape case led to the relentless marches and the spearheaded protests by the Ministry of Child and Women Development, which led to the emergence of the special law termed as a POCSO. It is an achievement with the introduction of POCSO in the field of preserving child rights in conjunction with the legislation to protect the sexually abused child. The introduction of the Act also further stamped out with another legislation, that is Prohibition of Child Marriage Act 2006, to end child sexual abuse. Then POCSO and the amended JJ Act 2015 cohesively provides a platform to allow wholesome perception of child rights jurisprudence. Even the introduction of the POCSO undoubtedly made a significant contribution, but it could not tackle properly the issues of child sexual abuse wholly. It is learned that the conviction rates in POCSO cases are at a meager 20%, and more than 90% of the cases are still pending. So to understand what is the issue, we have to understand the functionality of the special courts under the POCSO Act. So firstly, we have to understand why is there a faster delivery of cases. So firstly, the establishment of the POCSO provides that the child victims to have a faster delivery of cases. The statute under section 22 of the Act asserts about it. And the whole idea even slows down if observed in the case of State versus Yesho Babu. In this case, the special court judge stated that the meeting deadlines for a faster delivery of case is unreasonable, as the special courts have to prioritize cases dealing with other legislations. The incompetence to aid in a faster delivery of cases is a flaw in itself. Then secondly, the courtroom design is a debatable issue. Under section 33 clause 4 of the POCSO Act 2012, it presses an idea of child-friendly atmosphere where a child feels comfortable. A study on special courts in the cities of Pune and Thane reveals that for a child sexual abuse who comes to the court for hearing, no seating arrangements are provided to the child victims. The courts are not at all special. They're same courtrooms where regular cases takes place, and not the slightest concept of child-friendly under section 33 clause 4 of the POCSO Act is adhered to. And thirdly, the recording of the testimony is also very important under the POCSO Act, which is defined under 36 clause 1 of the POCSO Act 2012. It states that the child victims should not be exposed to the accused while the victim's recording of evidence is in progress. The child court should use viable options like video conferencing, single visibility mirrors, and any other alternative to record child's evidence so that child feels safe while recording the statement. So concluding the 3 points, it is clear that there lies faults in the functioning of the special courts. It is very important to deal with the issue by all states so as to uplift the mechanisms of POCSO. State government should also take initiatives and make strengthen the infrastructure of the special courts. Now, the main idea is about the analysis of the recent skin-to-skin judgment. The recent judgment is of the Bombay High Court of the Nagpur bench, which was delivered actually by a lady judge, Pushpa. In the case of Satish versus State of Maharashtra, it confirms that even a woman can set an incorrect example of protecting her own gender. It is a classic case of recklessly and insensitively dealing with the POCSO laws. The judge has come to terms through this judgment that skin-to-skin touch is a prerequisite for sexual assault. The facts of this case is the perpetrator of the order accused groped a 12-year-old child. The charge was put on the accused to convict him included section 8 of the POCSO Act 2012, which was read with various sections like 354, 363, and 342. The accused should, however, be sentenced by the High Court for a minimum 3 years of the imprisonment under Section 8 of the POCSO Act, which was set aside by the High Court. And the sentence was decreased to just 1 year under Section 354 of the IPC. The Supreme Court has stated a controversial order as it was submitted by the Attorney General, and Attorney General said that the judgment is quite unprecedented and is likely to set the precedent. So just lastly, focusing on the expanding the scope of POCSO, in brief, just 1 minute. The roots of the POCSO needs to strengthen and broaden the inclusive of the evolving crimes committed on the child sexual abuse. Even though the POCSO has been a boon to the society, the failures highlight the inefficiency of the law. The recent skin-to-skin judgment shows the defect of the POCSO and its inability to deal with the historical cases. And the concept of historical child sexual abuse points to delayed reporting of the child sexual abuse cases. There are many cases which they couldn't report at that point of time, and due to which a lot of cases stays unreported. So the circumstances of child history may be atrocious and threatening. The law just cannot claim that since the reporting is not done within the limited time period, it cannot count as a crime. There can be reasons for fear of public humiliation, or maybe the child abuse has no one to trust to. So finally, India lacks procedural guidance to deal with historical cases, but other countries such as UK can be witnessed to have a detailed guidelines to prosecute child sexual abuses, and we should adopt it accordingly. And concluding in a snippet, the understanding of POCSO needs unlearning of the criminal law. It is more of a child-friendly act. The child who is sexually abused needs counseling and proper treatment to be emotionally stable and confident to move in the society. India lacks trained counselors to tackle the huge amount of child sexual abuse. The counseling needs huge costs from the government, and such counselors should be available at all times. The infrastructure of special courts are at a dismal stage. At first, proper infrastructure should be built. Also, the amount of sexual abuse percentage are increasing in time to encourage this massive exercise. Awareness should be spread. Recently, an NGO filed a PIL to introduce a short video before a movie commences in the movie theater relating to spreading awareness about child sexual abuse. It is the first ever broad step taken to spread awareness on child sexual abuse. Thank you so much.
Thank you so much, Pula. It's you have tried to cover almost all the points in different facets of child sexual abuse, with the child psychology, then in terms of the prosecution, in terms of what the judiciary should expect, the sensitization of the not only judiciary, administration, lawyers, and all the people or stakeholders which may be involved to give justice for the child. So it's very enriching presentation and the research you have done. Thank you so much for
that. I couldn't present my slides because of some technical glitch. It's not working out here.
No problem. It happens. It happens. Some things are beyond our control. So it doesn't matter. In spite of giving the slides also, your presentation is very good. So I'll just open the floor for the question and answer. So if the organizer permit us, we can have some questions for next 10 minutes, and then we will conclude the session. So
yes, sir. So we can have a question answer round.
So I think we have more 10 minutes in our hand, or we are running short of time.
So we are a little short of time, sir. We can have it for 5 minutes, sir.
Okay, so we'll have for 5 minutes. So just raise your hand or unmute your mic and ask the question. Panila wants to ask questions. So Panila, go
Yes,
ahead.
sir. So my question to Mr. Simon is that, hello,
Yes,
am I
Panila.
audible?
Audible.
Yes, hi Simon.
You are audible. You can also open your, you can also enable your video also if you want.
No, Sam, it's fine. My question to Simon, Mr. Simon, is that do you like really think that the POCSO Act is gender neutral in application? Because I mean, in case of minor boys, they do not have Section 364 of the IPC to fall back and seek justice. You know. So what do you have to say on that?
Thank you, Panila. Uh, I, I think actually, this is a very big loophole of POCSO Act, and it doesn't include the idea of child, the male child, boy child in it, and it is more it's more tilted towards women, like the IPC is tilted toward the women. So I think some amendments are required presently on this issue, and so that there's a gender neutral law that survives, and that's a that blankets all over the society.
Okay. Thank you. Next question.
Panila, are you satisfied with your answer?
All right. Thank you.
Sir, I suppose we don't have any other questions. I'm looking for it, but we don't have in the chat box also.
Any other? Just will give 1 minute to participants who wants to ask question. Otherwise,
Yes. Thank you so much.
I just want to ask question to other participants that Dr. Sushma Sharma has dealt with the women and their safety in modern India. So, what is her take that after passing this Vishaka guidelines and this sexual harassment of at working place that act has enacted by the government? So, with this current change in technology, there are some still there are major issues with safety of the women with this change in technology. So what do you want to say that how government should come up with the new statute, or what provision has to be changed, or what they have to look into?
Thank you so much, sir, for the question. Sir, I think that with the technology is correctly pointed out, we can install CCTV and in the public places, so that the this harassment problem can be addressed, so that there is always problem regarding the witnesses in these type of offenses. But then, sir, the problem is that the harassment is not just at the public place. What about the harassment at home? So unless and until we don't have that, we don't have that in our social system, when we don't bring our upbringing that the boy and the girl is same and the equal, and if there is upbringing should be such that the nobody should see women as just an object. So you can see that just 3 days before, in 30th July, in Madhya Pradesh, district court has given the judgment verdict that the father who raped his 8 years old daughter, and he threatened his wife that if she will go out and complain, he will kill. So in that case, district court has taken the measure and given 20 years of imprisonment, rigorous imprisonment to that person. So such stringent punishment should be there, sir.
Okay, thank you, Sushma ji. So
Thank you, sir.
this is major challenge is with the punishment. So stringent punishment can be it may help to curb the such crime, and it will create the or increase the safety of the women as well as the confidence amongst the women that they are safe, and it will be a deterrent kind of thing for the other public also. So I'll just move to, because we have short of time, so I just move to Dr. Tombing and Benchilio that they have discussed about the Naga customs and their administrative and political control and this justice and now for the Naga tribes. So, what is your stake with this government that citizenship, that new act government has come up to prove the citizenship? Is it affecting the Naga people, or it is just related with the states which share the boundaries with the Bangladesh?
Naga issue actually has run into a stalemate, and the challenge is, in fact, the constitution and flag itself, which is quite a challenge itself. And before any other aspects of international borders and other issues are being spoken or maybe discussed also within the state itself, because the idea of Naga sovereign state from a sovereignty to an arrangement within a constitution setup and then a constitution within a constitution, the inhabitants of Naga and then the idea of Nagaland has its presence felt in state of Assam, Arunachal Pradesh, Manipur also. And in fact, in the international boundaries that is being shared with Myanmar and other concerns. Now, within the nation of India itself, that union territory, and then the extent of the union territory, and then the administration of laws, and then all the national laws that are there, special provision is already there. Now, context is, do you bring in other aspects of issues of this residence issues and then domiciles issue? This is one part, but then also once finally things are settled and things comes in order, there's always this aspects of how do you deal with this law. For example, in Ratan Singh versus state of Nagaland, and also in the case of Khudiram versus Arunachal, state of Arunachal, and also in the case of state of Nagaland versus human rights and other issues. The idea is that the spirit of neither CRPC nor IPC are applicable. Only the authority part is applicable. So, in fact, in Ratan Singh versus state of Nagaland, Justice Hidayatullah said this is a backward track. But then that backward track and then the judgment was all way back in 1966. And there's actually an international level challenge in the statement that Isaac Muiva has made in an interview with Karan Thapar in The Wire. He said that history part in the cultural expression and self-determination, that India history may be this, but then Nagaland and then people of Naga has this unique history. Now, how do you define that unique history? That would be quite a challenge. And to give a clear-cut answer, it will be very difficult because that will require much more deliberation and discussion.
Okay, thank you, Dr. Toming. This is very much inciting, and this new aspect that not only this Naga means this issue is much more wider, and we have to think it in different perspective. So
yes.
So thank you so much. You have given this and this judgments and what this Supreme Court has stated also. So thank you so much. So I just come to Dr. Astha with one small question that regarding this. Currently, Supreme Court is dealing with this suo motu writ petition for this COVID vaccine policies, and then in that writ petition, Supreme Court is dealing also with this mismanagement of the field or demands for oxygen and other things. So, what is your opinion or what is your stake for stating that whether Supreme Court should deal with this medical professional or what you have stated in your presentation that medical professional or profession should show some responsibility and responsibility towards the citizen of India and towards these people, those who are COVID affected people. So whether Supreme Court should pass some guidelines in the same writ petition or, and also what is your stake with this COVID vaccine policy? Just you can enlighten for one minute, or if you have research would cover this topic, then just share the thought your thought with us. I think she has been disconnected. Krushanu?
Yes, sir.
So Dr. Asma is not there, right?
Yeah, I'm here. I am very much here, sir.
So just can you just share with us your opinion about this COVID suo writ petition? Currently, Supreme Court is dealing with COVID vaccine policies and other things. Have you heard the question, right?
No, sir, I have not heard about this caption. But so far as the vaccination is concerned, so this is the major we should we should treat we should take it very seriously, because that is the only major in our hands, so that we can prevent the spread, because of
I think there is some technical problem with Dr. Asma. So I'll I'll uh, I'll thank all the participants and the organizer for inviting me and requesting me to chair this very wonderful session covering different topics about the law, and we can say it is law and other things, because we have covered this women's safety, then issues of Nagas, and then COVID vaccine policies and COVID-19 and medical profession, their responsibility, and POSCO Act. So considering this whole entire uh, uh, varieties of topics, we can say that in the present situation of COVID pandemic, where world has distorted and we are uh, coming together and discussing with each other with this virtual platform, we don't know whether when it will going to stop, or we are praying that it should stop as early as possible. But with this, all these different topics, we can say that these are the most important topics. And with this coming challenges because of the COVID, we are facing different challenges because of the advancement of technology. And not only advancement of technology, there is now challenges because of this social distancing and other part, where people start suspecting each other, though that suspicious nature of the people, that should be reduced somewhere at some point of time, and the world should come together and everything should go normal. So there are various case laws are also that Mr. Pulak has when he has stated this Nagpur bench about this POSCO Act, but and he has one somewhere stated that unlearning of criminal law. So is it right that every time unlearning of criminal law is expected? Because this POSCO Act, suppose someone has been accused, then entire trial goes according to the criminal law. But so unlearning of criminal law to some extent it is acceptable, but entire unlearning, that may not be possible for the judiciary also. But he has rightly pointed out that child-friendly courts. So this is very important point, and the government has taken up this issue. When I was working with the Ministry of law and justice, there was a project in 13 Finance Commission earlier that they were come up with the model code, and in that model code there was one provision that code should be child friendly, not only for the POSCO Act, but that child friendly code will help for the matrimonial issues where people have their come to the court with their children, then issues with the Juvenile Justice Act and other various acts, or other various, it is for the client's purpose also, when they don't have places to keep their children and they come to the court. But no doubt the court premises is very depressing and we require a child friendly environment. Then this COVID-19 and medical profession, the Dr. Asma has very rightly pointed out that the responsibility, those although we consider these doctors as a frontline worker, but there are some people that we have observed or we have experienced, or our in the second wave, somebody of somewhere or some relative, some known person, they are in every family, they are affected with this COVID, and we have the experience that somewhere they say that medical professional or this doctor hasn't treated properly. So what are the responsibility of the doctor? That has also been defined. That a new concept has come up, that responsibility of the lawyers has to be defined. But not only that, we are dealing, just Dr. Asma has dealt with this medical profession. Then Dr. Tombing and Benchilio has discussed with this Naga customs and administration of justice. Justice is a subset of justice to subset of the Naga tribes. So not only justice to Naga community, but we have to consider the different Naga tribes, their different aspirations, and according to that, the judiciary and administration, they try to give justice, or they try to come up with the laws and regulations so that they should be given as a justice. So what is the concept of justice? This is also a part that when we go to the court, we say that we are getting a justice, but sometimes it is our experience that what the judge has given the judgment, that we call as a justice. So every time there may be a justice, there may not be a justice, but nonetheless, we say that there is a justice. We are going to the court. There is a three independent wings of this democracy, and judiciary is independent thing, and that is the reason we are believing on the judiciary. And last but not the least, Dr. Sushma Sharma, she has come up, she has dealt with the women and their safety in modern India. The name of the topic is big, but I'll just try to concise it. So when we say that Vishaka guideline in 1996, Justice J.S. Verma has given that judgment, and after that, from Vishaka to Nirbhaya, when we see that the entire journey of Supreme Court, or the entire journey of jurisprudence of for the safety of women, which has been evolved. And after Nirbhaya, the Supreme Court has asked all the states to create the Nirbhaya Fund. The fund has been created by the every state, and but the amount of the whatever has been created by the fund by the every state, that has not been distributed for the same purpose. So again, a case has been filed, and then in that case, the Supreme Court is just monitoring the case so that the fund can be utilized for the safety of women after the Nirbhaya case. So this is the evolution of jurisprudence regarding the safety of women. So entire these things, if we consider, this is the complete entire different perspective of law and other things, law and other issues, which we try to cover in the last 1 hour and 15 minutes. So thank you so much. Thank you all the presenters and viewers, and thank you so much for the organizer for inviting me and giving me the opportunity to listen your thoughts.
Thank you so much, sir, for taking time out of your busy schedule for
I would like to extend my gratitude to the organizers. Thank you for giving me opportunity, and congratulations for organizing such a wonderful program. Thank you.
Thank you so much. Thank you so much, ma'am. And sir, a special thanks to you for joining with us and chairing this session.